planning. So, all right, so we're getting tons of questions on this, and one of the big ones is that I've always been confused on is probate. Okay, what is probate, and do you have to go? I have a will, everything is fine. Why does it have to go through probate, John?
Well, probate is the process of clearing title to assets that we don't know what to do with. So some assets that you might have are not probate assets, such as like life insurance policy or retirement plan. Those would have pay on death designations. So those we pay directly to the named beneficiary. But if there was no named beneficiary, or in a lot of cases real estate is going to go through probate because we don't know what to do with it. So that's the process of clearing the title. A personal representative is appointed by the court to administer the estate, and then the personal representative collects those assets, sells the real estate, and distributes according to the will, if there was a will.
Okay, so let's just say that I have one remaining parent left, and they were to pass away, and in the will it said that I get their house, because I was the nicest kid. And just remember that, brothers and sisters. But no, that I would get it. I mean, that still has to go through probate, and if it does, how long does that usually take?
Yes, I had a client call the other day that he said that he was the personal representative of the estate, and I said, well, look, that's great, then all you need to do is get the sale package from the court to transfer the real estate. And but then in the conversation, it occurred to me that he was not he was the appointed personal representative under the will, but he wasn't appointed by the court. So the court is actually the entity that appoints a personal representative. So just because it says that you're the beneficiary under the will doesn't necessarily mean that you are that it automatically transfers to you. It has to go through the probate courts to have a personal representative appointed and then distributed according to the will. Because there could be multiple wills. We don't know if this is a valid will. It's the court that determines those things. So the probate process, it takes, a typical probate could take 4 to 6 months at the earliest. It could take longer depending on what type of assets need to go through the probate. We can do some summary administrations and some decree of descents if there are limited assets that need to go through there, if they're exempt assets.
Well, John, what's we're all about transferring real estate in here and how quickly it can happen. Give us an idea. What's the fastest you've ever seen a special administration where you've been able to transfer real estate for an upcoming closing?
Yeah, well, a special administration is where it's a proceeding within the probate proceeding. A special administrator can be appointed to handle a real estate transaction. There was one case where I was contacted on a Monday for a Thursday closing, and we were able to get a personal or a special administrator appointed within probably 24 hours. But that all the stars have to align. Everybody has to agree on this, but you can get things done very quickly if you need to.
Well, now the $10,000 question is that we always hear is how to avoid probate, for real estate. Are there some ways that you can convert your real estate into a non-probate asset so you can avoid the probate process?
Sure. I'd say there's 3 typical ways to avoid the probate. There's a transfer on death deed that's fairly new under Minnesota law. That allows you to name a beneficiary that will take the property upon your death. That document's revocable. It doesn't create a vested interest in the beneficiary, but it's a fairly inexpensive way to make that transfer happen. The second way would be the revocable trusts. You can transfer your property to a revocable trust, and then that separate entity then owns the property. And then under the terms of the trust, there's a provision during lifetime that says that the grantor gets to continue to live continues to get all the property during lifetime, and then upon death, then it just steps on to phase 2, which would be Chris Rooney apparently gets to inherit all property.
There you go. Let me ask you on that, on those revocable trusts, how soon prior to death do you have to set those up? I mean, is there a
5
waiting
minutes.
period or, oh, really? Okay.
Yeah, you'd have to set it up before death and transfer the property to the trust before death. But
Aren't those tax planning kind of things too, though, the irrevocable trust?
There are estate tax planning provisions that you can put into a revocable trust, but they don't have to be tax planning vehicles.
Okay, so someone that wants to do one of those, what is the process and where's the cost lie? And is it something that's got to be filed somewhere or recorded?
The trust itself is not recorded anywhere. You create the trust instrument, and then you draft deeds transferring the real estate into the trust. Those deeds are recorded in the county recorder's office for each county that you own property.
So let's just say that my parents did that for me and I was in charge of theirs. Could I sell their house?
If the trustee can sell the house, so if they are, typically the grantor is the trustee. You may be a co-trustee with them, depending on their age and their ability to manage the assets. But you would probably be the successor trustee. So upon their passing, you'd step in as successor trustee, and then the very next day you could transfer the real estate.
Okay, now what if they were still alive and I wanted to move them to a townhouse instead, but I had the house? Can you do that?
If they are no longer capable of being
Making
the
that
trustee,
decision? Okay.
then you can step in. But usually there's some provisions that allow for the successor trustee upon incapacitation.